Welcome to this final video on the ICJ. International courts and tribunals can be involved in the protection of a number of global values, such as peace and global health. In this video, we'll be looking at the role that the court plays in the protection of the environment, another global value. Since the 1990s, the ICJ has handled a number of disputes between states that relate to the protection of the environment. Cases concerning the environment tend to involve the public interest in issues such as preventing air and water pollution and the protection of wildlife. We'll explore three different cases that related to the environment. First, the Gabčíkovo Nagymaros project. Second, aerial herbicide spraying. And third, whaling in the Antarctic. The first case we'll look at concerned the construction of a large hydroelectricity plant along the Danube River, which separates Hungary and Slovakia. This was known as the Gabčíkovo Nagymaros project. A dispute arose between Hungary and Slovakia about a treaty that the two states signed in 1977, when Slovakia was still a part of Czechoslovakia. Under this treaty, both states committed themselves to constructing and operating a series of locks along the Danube River for the purpose of generating hydroelectricity. Hungary and Slovakia began work on the project in 1978, but by 1989 the Hungarian government had decided to abandon the project. The project had generated intense criticism in Hungary regarding its ecological viability. The Hungarian government's decision to abandon the project was partly a response to domestic pressure about the project's potential environmental consequences. The interests of the Hungarian people in maintaining the water quality of the Danube River formed part of the backdrop to this case. In its 1997 judgment, the court focused mainly on whether the treaty between Hungary and Slovakia was still in force. But the court also made a few notable statements about international environmental law. In particular, the court explained that economic development must be reconciled with the protection of the environment. In other words, hydroelectricity projects like the Gabčíkovo Nagymaros project have to be designed with a view towards balancing economic development with environmental considerations. While the court ultimately held that the 1977 treaty was still in force between Hungary and Slovakia, it encouraged the two states to look again at the effects of the project on the environment. The second case we'll look at concerned the aerial spraying of herbicides by Colombia near its border with Ecuador. From 2000 to 2007, Colombia sprayed coca crops with herbicides from airplanes in order to try to curb the trafficking of cocaine. Ecuador alleged that Colombia's aerial spraying of herbicides had caused serious damage to the Ecuadorian environment, its people and their crops, and animals in the border region. Ecuador specifically alleged that the herbicides had sometimes blown across the border from Colombia into Ecuador, causing widespread and serious damage in Ecuador. This case raised interesting legal questions about transboundary environmental harm, questions that the court had never dealt with before. But as it turned out, the court never had an opportunity to rule on these issues in this case. After Ecuador filed its case at the ICJ in 2008, Ecuador and Colombia submitted lengthy written arguments and evidence to the court over the course of the following years. But at the same time, the parties pursued negotiations on the issue of aerial herbicide spraying in an attempt to settle this dispute on their own terms. In 2013, Ecuador and Colombia managed to reach an out-of-court settlement before the court could hear the parties' oral arguments and deliver a written judgment. This settlement imposed a series of limitations on Colombia with respect to any future herbicide spraying in order to prevent herbicides from drifting into Ecuador. In this case, two different forms of international dispute settlement were ongoing at the same time. While Colombia and Ecuador were in the process of settling their dispute through adjudication at the ICJ, they were also pursuing negotiations, a more flexible and less costly form of dispute settlement. The court's role in the resolution of this dispute was therefore indirect. The process of litigating the case at the ICJ may have encouraged the parties to settle their dispute through negotiations, so that they could control the terms of the settlement. In other words, litigation at the ICJ may have facilitated the success of the parties' out-of-court negotiations. The last case that we'll look at concerned the Japanese government's whaling program in the Antarctic. Australia challenged Japan's program in a case that it brought to the court in 2010. Unlike the cases between Hungary and Slovakia and Ecuador and Colombia, Australia did not argue that Japan's whaling practices harmed its environment or its people. The Australian public interest in challenging Japan's whaling program was more remote in this case. Australia claimed that Japan's whaling program was in violation of the International Convention for the Regulation of Whaling. Both states are parties to this treaty, which put an end to commercial whaling in the 1980s because stocks of certain whale species were being depleted at that time. After the prohibition on commercial whaling came into effect, Japan launched a scientific whaling program. Japan viewed this program as falling within an exception to the prohibition on whaling. Under this program, Japan killed hundreds of whales every year for what it deemed to be scientific purposes. But in 2014, the court ultimately determined that Japan's program was indeed in violation of the terms of the treaty, and it ordered Japan to discontinue its program. This case highlighted a long-standing conflict between, on the one hand, states with a tradition of whaling and an interest in reviving the whaling industry, and on the other hand, states that have instead pressed for the conservation of whale species. These three cases show that the court has the potential to play a role in the protection of the environment and wildlife, though in an indirect or remote way in some cases. Because the protection of the environment remains a pressing issue for many states and their citizens, we're likely to see the court handling more and more environmental disputes in the future. I invite you to join me for an inside look at the ICJ through an interview with Judge Greenwood in the next video.